Courtroom dialogue, judge and accused. Judge: Mr. Bard, you are here today to answer to the charges brought against you. How do you plead, guilty or not guilty? Accused: Your Honor, before I can enter any plea, I am here by special appearance solely to challenge the jurisdiction of this court. I require the prosecution to prove on the record that this court has both subject matter and personal jurisdiction over me and this matter. Judge: This is a criminal case, and this court has jurisdiction over such matters. You need to enter a plea. Accused: Your Honor, I do not waive any rights and do not concede jurisdiction. I respectfully request that the prosecution prove, on the record, every element of jurisdiction, including subject, matter, personal, and territorial jurisdiction. Until that is done, I cannot enter a plea. Judge: The court assumes jurisdiction because this case falls within its legal authority. Now, how do you plead? Accused: I object, Your Honor. I do not accept the court's assumption of jurisdiction. Assumptions are not proof. I challenge and rebut any and every presumption of jurisdiction. I require the prosecution to provide evidence of proper jurisdiction on the record. Until they do so, this court has no authority to proceed. Judge: The charges are filed in this court, and that gives us jurisdiction over you. Enter a plea. Accused: Your Honor, I respectfully object. Filing charges alone does not grant jurisdiction. I am not submitting to the court's authority until the prosecution provides evidence that this court has subject matter jurisdiction, personal jurisdiction over me, and territorial jurisdiction, all of which must be proven on the record. I demand proof, not presumption. Judge: Mr. Bard, you cannot delay these proceedings. This court has jurisdiction, and you must enter a plea. Accused: Your Honor, I am not attempting to delay. I am simply invoking my right to challenge the court's jurisdiction, which is a fundamental element that must be proven before any. Proceedings continue. The burden of proof is on the prosecution, and until they satisfy that burden, I cannot proceed. Judge, turning to the prosecutor: Does the prosecution have any evidence to present on jurisdiction? Prosecutor: Your Honor, the charges have been filed in this court, which has the authority to hear criminal matters. The defendant resides in this jurisdiction, and the alleged crime occurred here. Accused: I object, Your Honor. The prosecutor's statements are not evidence. I demand specific, factual evidence be placed on the record to prove jurisdiction. The court must establish, through admissible evidence, that it has jurisdiction over both the subject matter and my person. The prosecutor has presented none. Judge: Mr. Bard, these are standard proceedings. The court has jurisdiction based on the charges and the location of the crime. Accused: Your Honor, I again respectfully object. Legal standards cannot replace factual evidence. I challenge the court to provide factual evidence of jurisdiction as assumptions and standard practices do not fulfill the legal requirement of proof until jurisdiction is established on the record. I do not submit to this court's authority, nor will I enter any plea. Judge: Mr. Bard, you are required to follow the procedures of this court. Accused: Your Honor, I understand. However, I am exercising my right to challenge jurisdiction, and I request that this court acknowledge that no plea can be entered until jurisdiction is proven. I reserve all rights and rebut all presumptions that this court has jurisdiction unless it is established on the record. Prosecutor: Your Honor, we believe the defendant is attempting to delay the case. Accused: I object, Your Honor. I am not attempting to delay anything. I am exercising my right to ensure that the court is operating within its lawful authority. Jurisdiction must be proven, not presumed, and I am merely requiring the prosecution to do their duty and establish it with admissible evidence. Judge, you have made your point, Mr. Accused's name. However, the court will move forward. I will ask you once more, how do you plead? Accused, Your Honor, with all due respect, I cannot and will not enter a plea until the prosecution has proven jurisdiction on the record. I maintain my challenge and my objection to the court's authority to proceed until this matter is settled. Judge, Mr. Bard, this court has already stated that we have jurisdiction based on the location of the alleged crime and the charges. You are delaying the proceedings by refusing to enter a plea. I must warn you that if you continue, there could be consequences for obstruction. Accused, Your Honor, with all due respect, I am not obstructing these proceedings. I am asserting my legal right to challenge the court's jurisdiction, which has not yet been proven on the record. As you are aware, once jurisdiction is challenged, it must be established under law, not by presumption or assumption. Judge, the prosecution has already stated that the crime took place within this jurisdiction, and you reside here. What more do you require? Accused, Your Honor, I respectfully submit that statements from the prosecution are not evidence. In a matter this serious, the court cannot proceed without proof of jurisdiction that complies with the law. The court cannot assume jurisdiction based on mere assertions or location. It must be proven. I demand that the prosecution produce lawful evidence demonstrating this court's authority to hear the case. Judge, this court handles criminal matters like this every day. We have jurisdiction, and the charges have been properly filed. I am asking you for the last time, how do you plead? Accused, Your Honor, I again respectfully object. It is established law that jurisdiction must be proven once challenged. I have raised a challenge, and the prosecution must meet the burden of proving with evidence that the court has subject matter, jurisdiction, personal jurisdiction, and territorial jurisdiction. Until they provide this proof, any actions this court takes would be void ab initio, without legal effect. Prosecutor, Your Honor, we have already indicated that the crime occurred within the state, and that the defendant lives in this jurisdiction. That should be sufficient. Accused, I object. That is not sufficient under the law. I require the prosecution to prove these elements through proper documentation or admissible evidence on the record. Merely stating that a crime allegedly occurred here is not enough. The law requires proof, and I challenge the prosecution to present it. Judge, the court has jurisdiction. We are moving forward. Accused, Your Honor, I must object again. If the prosecution cannot produce evidence on the record that establishes jurisdiction, I move for dismissal of the case for lack of jurisdiction. Under constitutional and common law principles, jurisdiction must be proven, not presumed. Any further actions taken by this court without proper jurisdiction would be ultra vires, beyond the court's legal authority. Judge, annoyed. This is not the time for legal lessons you are expected to participate in. These proceedings like anyone else. The court has jurisdiction, and we will proceed. Accused, Your Honor, I do not seek to lecture, but I must insist on the rule of law. The prosecution must meet its burden. I cite the case of Ex parte Young and others which demonstrate that jurisdiction must be established once challenged. This is not a trivial matter. I respectfully demand that the prosecution produce evidence, whether in the form of affidavits, certified records, or other lawful documentation that proves jurisdiction. Until this is done, I cannot proceed in any other manner. Judge, turning to the prosecutor, does the prosecution have anything further to add on jurisdiction? Prosecutor, we have already explained that the crime occurred within this court's jurisdiction, and we have presented the charges. Accused, I object again, Your Honor. The prosecution has only made assertions which are not. Evidence. I require the production of specific evidence on the record to prove jurisdiction. The law requires proof, not allegations. I demand to see documentation, such as the lawful authority, under which this court is proceeding, proof of proper service, and any other necessary evidence to establish the court's jurisdiction. Judge, frustrated. Mr. Bard, the court has already stated that we have jurisdiction. I will not entertain this further. Accused, Your Honor, respectfully, I must continue to challenge jurisdiction until it is proven, according to law. By refusing to provide proof of jurisdiction, this court is acting beyond its lawful authority. I move for dismissal based on lack of jurisdiction. If jurisdiction cannot be proven, then this court has no lawful standing to proceed. Judge, we are not dismissing this case. This court has jurisdiction, and we are proceeding with or without your cooperation. Accused, Your Honor, I maintain my challenge to jurisdiction and continue to rebut any and all presumptions. Jurisdiction has not been proven on the record, and any actions taken without such proof are null and void. I will not concede to jurisdiction until the prosecution has fulfilled its legal obligation to provide evidence of the court's authority over both me and this matter. Judge, Mr. Bard, the court has already stated that it has jurisdiction over this matter. We are moving forward, and I will ask you again, how do you plead? Accused, Your Honor, respectfully, I must object again. It is well established in law that once jurisdiction is challenged, the burden lies with the prosecution to prove each and every element of jurisdiction. This includes subject matter jurisdiction, personal jurisdiction, and territorial jurisdiction, until the prosecution submits actual admissible evidence to substantiate any claims of jurisdiction. This court cannot lawfully proceed. I do not consent to this court's jurisdiction, and I require that it be proven on the record. Judge, the court has jurisdiction over the crime alleged to have been committed in this jurisdiction. Your repeated objections are delaying the proceedings. Accused, Your Honor, respectfully, delays are irrelevant where the court's jurisdiction is in. Question, without jurisdiction, this court has no authority to take any actions, and any rulings or judgments would be null and void from the start. Presumptions are not evidence. The prosecution must provide actual admissible evidence to prove jurisdiction, and until that happens, the court is proceeding unlawfully. Prosecutor, Your Honor, the crime occurred within the state. The defendant lives here, and the charges were filed properly in this court. We assert that jurisdiction is clear. Accused, I object, Your Honor. Once again, the prosecution's assertions are not evidence. They are merely claims. I require the prosecution to present actual, tangible proof, such as properly authenticated documentation or other admissible evidence to establish each element of jurisdiction. Mere statements by the prosecution do not satisfy the burden of proof. Judge, Mr. Bard, this court is authorized to hear criminal matters in this jurisdiction. I see no reason to delay further. Accused. Your Honor, with respect, I must point out that the court cannot proceed unless the prosecution proves every element of jurisdiction under law. The prosecution has failed to provide any actual evidence until they can produce evidence of 1. Subject matter jurisdiction, the court's authority to hear the type of case at hand. 2. Personal jurisdiction, that the court has authority over me as the accused. 3. Territorial jurisdiction, that the alleged crime occurred within this court's lawful territory. This court cannot proceed. Any presumption or assumption without evidence is a violation of due process. Judge, becoming more frustrated. This court handles criminal matters on a daily basis. Jurisdiction is presumed by the nature of the charges filed and the location of the crime. Enter a plea, Mr. Bard. Accused. Your Honor, I object again. Presumption of jurisdiction is not enough under the law. Jurisdiction must be proven on the record when it is challenged. I challenge and rebut any presumption of jurisdiction, and I demand actual evidence. The prosecution cannot simply claim jurisdiction exists. They must prove it with documentation, affidavits, or other valid evidence. Without that, this court has no authority to compel me to enter a plea or proceed in any way. Judge, you are stalling these proceedings. This court has jurisdiction. The case is moving forward. Accused. Your Honor, I respectfully disagree. The prosecution has presented no actual evidence to substantiate jurisdiction. Every step forward without proper jurisdiction is a violation of due process, and the record will show that this court proceeded without lawful authority. I reiterate, I do not consent to this court's jurisdiction unless and until it is proven with evidence. The law requires that all elements of jurisdiction be established before any further proceedings. I request the dismissal of this case for lack of jurisdiction if the prosecution cannot meet its burden. Prosecutor. Your Honor, we have filed the necessary charges, and the court has jurisdiction by statute. The defendant lives within the jurisdiction of this court, and that should be sufficient. Accused. I object again, Your Honor. The prosecution is repeating assertions without providing actual proof. The location of my residence does not alone establish personal jurisdiction in a criminal matter. The law requires the prosecution to prove with evidence that all elements of jurisdiction are satisfied, not just through assertion. I request certified, verifiable proof that 1. The court has legal authority to hear criminal cases of this type. 2. The alleged crime occurred within this jurisdiction's territorial bounds. 3. That I have been properly served and brought under the court's lawful personal jurisdiction. Until this proof is provided, I maintain that this court cannot proceed lawfully. Judge, Mr. Bard, I will not allow you to derail these proceedings further. Enter a plea now, or I will hold you in contempt. Accused. Your Honor, with all due respect, I cannot and will not enter a plea until jurisdiction is proven. I cannot be lawfully compelled to submit to this court's authority unless the prosecution provides the required proof on the record. I understand the court's frustration, but the law is clear. Jurisdiction must be proven once it is challenged, and the prosecution has not done so. Therefore, any actions taken by this court without that proof are outside its lawful authority. I move for dismissal based on the lack of jurisdiction. Judge, to the prosecutor, can the prosecution provide any further evidence on the issue of jurisdiction? Prosecutor, hesitant. Your Honor, the charges have been filed in this court, which has the proper authority, and the defendant resides within the jurisdiction. We believe jurisdiction is sufficiently established. Accused. I object, Your Honor. The prosecution's belief does not constitute legal proof. Beliefs and assumptions do not establish jurisdiction under the law. I require the prosecution to provide certified evidence of jurisdiction, such as authenticated documents proving the location of the alleged crime and any statutory authority the court relies on for subject matter jurisdiction. Until that is presented, I move for dismissal, as the court is proceeding without legal authority. Judge, turning to the prosecutor. Do you have any documentation to present? Prosecutor. We can gather the necessary documentation, Your Honor, but we have already asserted that this court has jurisdiction. Accused. Your Honor, assertions and gathering of evidence after the fact do not satisfy the legal standard. Jurisdiction must be proven before the court can lawfully proceed. I request that the court dismiss this case for lack of jurisdiction, or in the alternative, that the court compel the prosecution to provide the required evidence before proceeding any further. Judge, frustrated. Mr. Bard, we cannot continue indefinitely with these objections. This is a court of law, and the prosecution has presented their case. The charges have been filed, and the court has jurisdiction. Enter a plea now, or face the consequences. Accused. Your Honor, I understand the court's frustration, but this is not about delaying the proceedings. This is about ensuring that due process is followed. The law is clear. Once jurisdiction is challenged, the court must halt all proceedings until it is proven on the record with actual evidence. Presumptions, assertions, or even the filing of charges do not substitute for evidence of jurisdiction. As the prosecution has not yet provided that evidence, this court cannot lawfully proceed. Judge, you are being uncooperative, and I will not allow this to go on any longer. Accused, Your Honor, respectfully, I am not being uncooperative. I am exercising my legal rights. Jurisdiction is the foundation of any lawful court proceeding. Without it, any rulings, orders, or actions taken by this court would be legally void from the outset. I am not refusing to cooperate. I am simply demanding that the prosecution follow the law and provide evidence. That proves this court has lawful authority over me and this matter. Prosecutor, Your Honor, we can provide additional documents to demonstrate jurisdiction, but we assert that jurisdiction is already evident based on the charges and location of the crime. Accused, I object again, Your Honor. The prosecution is once again relying on assertions without providing evidence. I challenge the prosecution to submit certified, factual documentation that proves 1. Subject matter, jurisdiction, the court's lawful authority to hear this type of criminal case. 2. Personal jurisdiction, that the court has lawful authority over me as the accused under proper legal process. 3. Territorial jurisdiction, that the alleged crime occurred within this court's geographical authority. Until these elements are established on the record, this court has no lawful authority to compel me to participate in any proceedings, including entering a plea. Judge, angrily. Mr. Bard, I will hold you in contempt of court if you continue to refuse to cooperate. Accused, Your Honor, with all due respect, holding me in contempt for insisting that the law be followed would be an abuse of power. I have the right to challenge jurisdiction, and the court has an obligation to prove its authority before proceeding. If this court has the proper jurisdiction, it should be able to provide clear documented evidence to that effect. If jurisdiction cannot be proven, then any further action would violate my constitutional rights and the rule of law. Judge, We have jurisdiction and we are moving forward. This is your last warning. Enter a plea or I will hold you in contempt. Accused. Your Honor, I cannot in good conscience enter a plea until jurisdiction is proven. The prosecution must meet their burden to provide actual evidence, not assumptions. I will not consent to the court's authority unless it is established under the law. If the court chooses to proceed without proving jurisdiction, I will have no choice but to appeal this case and seek dismissal on those grounds. Prosecutor interjects. Your Honor, we can provide certified copies of the indictment and the location of the crime. However, we maintain that the defendant's objections are unnecessary. Delays. Accused. I object again, Your Honor. The indictment alone does not establish jurisdiction. I require proof that this court has the proper legal standing to hear this matter and authority over me as the accused. If the prosecution claims that jurisdiction is established by statute or law, they must present that statute, along with factual evidence that ties this case to that jurisdiction. Judge, turning to the prosecutor, provide the necessary documentation to establish jurisdiction. Do you have the certified documents with you today? Prosecutor, hesitant. Your Honor, we do not have them immediately on hand, but we can provide them in due time. Accused, Your Honor, I move that the case be dismissed or at the very least halted until the prosecution can provide the necessary evidence to prove this court's jurisdiction. The law requires that the prosecution establish jurisdiction before any further action can be taken. Proceeding without proof of jurisdiction would be a violation of due process. Judge, annoyed but forced to comply. The court will take a recess to allow the prosecution to produce the required documents proving jurisdiction. The court cannot continue without the necessary proof. Mr. Legalese, ensure that you have the certified evidence when we reconvene. Judge, the court is back in session. Mr. Legalese, the defense has challenged the jurisdiction of this court. You were given time to gather the necessary documentation to establish jurisdiction. Are you prepared to present that evidence now? Prosecutor. Yes, Your Honor. We have provided a certified copy of the indictment, which details the charges and states that the alleged offense occurred within this jurisdiction. We also have a record showing that the defendant resides within this jurisdiction. Accused. Your Honor, I object. The prosecution's evidence so far consists of a certified indictment, which does not by itself prove jurisdiction. An indictment merely states accusations. It is not proof of jurisdiction. As for the claim that I reside within this jurisdiction, personal jurisdiction must be established through lawful process, and I require proof that the court has followed that lawful process, not just assumptions based on my residency. I request that the prosecution provide additional admissible evidence to establish every element of jurisdiction. Judge, turning to the prosecutor. Mr. Legalese, the defense has raised further objections. Do you have additional evidence to address personal jurisdiction and the location of the alleged crime? Prosecutor. Your Honor, the fact that the defendant resides here and that the crime occurred within the state should suffice to prove jurisdiction. We believe no further evidence is necessary. Accused. I object again, Your Honor. The residency of the accused alone does not establish personal jurisdiction. Personal jurisdiction is only established through proper legal service and process. I require the prosecution to provide proof that I was served in compliance with the rules of law and that all necessary steps were taken to bring me under this court's jurisdiction lawfully. Without this, the court cannot claim personal jurisdiction. Judge, Mr. Legalese, can you provide evidence that the defendant was served? properly according to legal procedures? Prosecutor, pausing. Your Honor, the defendant was present in court today, and it is understood that he is aware of the charges, so service was effectively completed. Accused, I object, Your Honor. Awareness of charges is not sufficient to establish personal jurisdiction. The law requires that proper service be conducted in accordance with legal procedures. The prosecution must provide proof of valid service of process to establish personal jurisdiction. I demand to see the legal documentation showing that I was lawfully served in compliance with all procedural requirements. Judge, turning to the prosecutor again. Mr. Legales, do you have proof of proper service of process? Prosecutor, looking through documents. Your Honor, I do not have the exact proof of service here, but the charges were filed and the defendant is present. Accused, I object again, Your Honor. Without evidence of proper service, this court does not have personal jurisdiction over me. The law requires more than my physical presence in court. Until the prosecution provides certified documentation proving that I was served in compliance with the legal process, this court has no authority to proceed against me personally. Judge, Mr. Legales, without proof of service, I am concerned about the validity of personal jurisdiction. What else can you present? Prosecutor, Your Honor, we can obtain the proof of service, but I believe we have already shown that the crime occurred within this jurisdiction. Accused, Your Honor, once again I object. The prosecution is now referring to territorial jurisdiction, but territorial jurisdiction also requires proof. The mere assertion that a crime occurred in a general area does not satisfy the burden of proof. I require specific evidence that the alleged offense occurred within the exact territorial boundaries over which this court has authority. General statements or assumptions are not sufficient. The prosecution must provide admissible evidence, such as sworn affidavits, police reports, or other certified documents establishing that the crime occurred within this court's jurisdictional boundaries. Judge, turning again to the prosecutor, do you have any certified evidence to prove the location of the alleged offense? Prosecutor, Your Honor, we have police reports that describe the location of the alleged crime, and it is within this jurisdiction. Accused, I object, Your Honor. Police reports, while potentially relevant, must be presented as admissible evidence. I request that these reports be authenticated and that the prosecution present certified copies with proper documentation verifying the exact location of the alleged offense. Until this is done, territorial jurisdiction remains unproven. Judge, pausing, then addressing the prosecutor. Mr. Legales, do you have authenticated copies of these reports? Prosecutor, looking through documents again. Your Honor, I do not have authenticated copies at this time. We can obtain them, but we maintain that the evidence already presented is sufficient. Accused, I object again, Your Honor. Unverified police reports are not sufficient to establish territorial jurisdiction. The prosecution must present properly certified evidence to prove the exact location of the alleged offense. Until this is done, this court has no authority to proceed. Without proper service of process and proof of where the alleged crime occurred, jurisdiction remains unproven and the case cannot lawfully continue. Judge, becoming visibly frustrated. Mr. Legales, it seems that the defense's objections have not been fully addressed. Do you have any further evidence to present? Prosecutor, Your Honor, we can obtain the necessary documentation, but it is our position that jurisdiction has already been established. Accused, Your Honor, I respectfully disagree. Jurisdiction cannot be based on positions or assumptions. The law requires actual admissible evidence. The prosecution has failed to provide proper proof of
On subject matter jurisdiction, that this court has authority over the type of case at hand.
2. Personal jurisdiction, that I was properly served and lawfully brought under the authority of this court. 3. Territorial jurisdiction, that the alleged crime occurred within the specific boundaries of this court's authority. Since none of these elements have been proven with the necessary evidence, I move for immediate dismissal of the case based on lack of jurisdiction. Judge, pausing. Mr. Legalese, I will give you one final opportunity to present any additional evidence to establish jurisdiction. Without it, I will have no choice but to consider the defense's motion to dismiss. Prosecutor, Your Honor, we will need additional time to gather the requested documentation. Accused, Your Honor, I object to any further delays. The prosecution has had ample opportunity to provide the necessary evidence, since they have failed to prove every element of jurisdiction. I respectfully request that this case be dismissed immediately due to the prosecution's inability to meet their burden. Judge, reluctantly. Very well. In light of the prosecution's failure to present adequate evidence of jurisdiction, this court is forced to consider the motion to dismiss. The court cannot proceed without every element of jurisdiction being established. Mr. Legalese, unless you have further evidence, I will grant the defense's motion. Prosecutor, defeated. We have no further evidence at this time, Your Honor. Judge, then, based on the lack of sufficient evidence to establish jurisdiction, this case is hereby dismissed. Court is adjourned. Key points throughout the entire dialogue. Year 1. Special appearance. The accused made a special appearance, clearly stating that they were appearing solely to challenge jurisdiction and not to submit to the courts. Authority. 2. Challenge to presumptions. The accused rebutted every presumption of jurisdiction, emphasizing that the court cannot assume jurisdiction and that all jurisdictional elements must be proven on the record. 3. Demand for proof of jurisdiction. The accused demanded that the prosecution provide actual admissible evidence to prove jurisdiction, not mere assertions or presumptions. This included subject matter, personal, and territorial jurisdiction. 4. Refusal to plead without proof. The accused refused to enter a plea until jurisdiction was proven, stating that any plea or participation in proceedings would concede jurisdiction. 5. Subject matter. Jurisdiction. Challenge. The accused demanded evidence that the court had the authority to hear the specific type of case, criminal in this scenario, and that the crime charged fell within the court's scope of authority. 6. Personal jurisdiction challenge. The accused required the prosecution to provide evidence of proper service of process to establish that the court had jurisdiction over their person, not just based on their presence or residency. 7. Territorial jurisdiction. Challenge. The accused demanded specific, verifiable evidence proving that the alleged crime occurred within the court's geographical area of authority, rejecting any general claims about location. 8. Objections to assumptions. The accused objected at every attempt by the prosecution or the judge to proceed based on assumptions, highlighting that jurisdiction must be proven and not assumed or inferred. 9. Burden of proof on prosecution. The accused repeatedly asserted that the burden of proving jurisdiction lies with the prosecution, not the accused or the court. This included all three elements: subject matter, personal, and territorial jurisdiction. 10. Request for certified documentation. The accused consistently requested certified, authenticated documentation to prove jurisdiction, such as affidavits, police reports, or other legal documents, rejecting unverified statements or reports. 11. Contempt avoidance. The accused remained respectful and avoided being held in contempt by clearly stating that they were exercising their legal rights and not attempting to obstruct the proceedings. 12. Due process violations. The accused argued that proceeding without proven jurisdiction would be a violation of due process and would render any court actions legally void from the start. 13. Constant objections. The accused maintained a consistent objection to any court action without proper jurisdiction being established, preserving the issue for potential appeal. 14. Citing legal authority. The accused referred to legal principles and case law, such as the fact that jurisdiction must be proven once challenged, citing constitutional grounds and legal precedents. 15. Jurisdiction rebuttal. Throughout, at every stage, the accused refused to accept jurisdiction until all elements were proven, continuing to object whenever the prosecution or judge attempted to move forward without sufficient proof. 16. Prosecution's failure to provide proof. The prosecution was unable to provide adequate evidence to prove personal jurisdiction, service of process, and territorial jurisdiction, location of the crime, leading to further objections by the accused. 17. Objection to delays. The accused objected to any further delays when the prosecution requested more time to gather evidence, stating that they had been given ample opportunity to provide the necessary proof. 18. Motion for dismissal. The accused repeatedly moved for dismissal of the case due to the prosecution's failure to prove jurisdiction. Without proof, the accused argued the court had no authority to proceed. 19. Judge's reluctant compliance. Despite frustration, the judge eventually complied with the legal requirements for jurisdiction after acknowledging that the prosecution had not provided the necessary evidence. 20. Court dismissal. Due to lack of jurisdiction, the case was ultimately dismissed because the prosecution failed to prove all the required elements of jurisdiction, subject matter, personal, and territorial, with sufficient admissible evidence. Summary of key points. Jurisdiction must be proven once challenged, and it cannot be assumed or presumed by the court. The burden of proof is on the prosecution to provide actual evidence of jurisdiction, including subject matter, personal, and territorial jurisdiction. Certified, admissible documentation is required to prove jurisdiction, not just assertions or assumptions. Refusing to enter a plea or participate in the proceedings until jurisdiction is proven protects the accused's rights and avoids conceding to the court's authority. Without proper proof, the court has no authority to proceed, and the case may be dismissed for lack of jurisdiction.
0, 1, 1, 2, 3, 5, 8, 13, 21, 34, 55 and beyond. Growth emerges from silence, from nothingness, zero. A single step of breath, one echo of itself. One from this reflection, duality arises. Tension, creativity, and motion. Through the spiral of life, expanding. 5, harmony in complexity. 8, an ascent to the unknown. 13, higher truths unfolding. 21, limitless possibility. 34, unseen forces align. 55, the tale that can be told is not the eternal